your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Friday, February 7th, 2025. And as happens from time to time on this show, now for something completely different. Over the years, we have a few times, instead of talking about the Federal Courts of Appeals or the latest in the law, discussed a recent book that's been published with its author. And I am very pleased to say that is what we're going to do today. Now, anyone who follows the Institute for Justice and what we do at the Center for Judicial Engagement knows the subject of occupational licensing. At IJ, we've published this report, License to Work. We've done a few editions of it, documenting occupational licensing across the country. We've done other reports. We, of course, have challenged many occupational licensing laws in state and federal courts across the country many times. And we've talked about many of those cases and other cases here on Short Circuit. So I think our audience will be excited to hear about this book, especially the title, which is The Licensing Racket. I mean, that's a good start, right? How we decide who is allowed to work and why it goes wrong. Now, it's published by Harvard University Press, and it's actually coming out a few days after we're recording the show on February 11th, but about 3 days before we plan to release it, which is on Friday, February 14th. 2025. So if you're just listening to this the day it comes out and you want to spread a little Valentine's love, go to the show notes and click to the book's page and you can buy a copy and spread a little bit of that love around. The author, who we have here today, is Rebecca Hall Allensworth. She is a professor at Vanderbilt University Law School. She is the Associate Dean for Research, the David Daniels Allen Distinguished Chair of Law. She has degrees from places like Yale and Cambridge and Harvard, and she even clerked for Judge Posner, which, that would be cool to talk about just for short circuit reasons. And she is primarily an antitrust scholar, but she got into this thing, occupational licensing. And so I want to welcome her to the show and hear what's her book about.
Well, first, I want to thank you for having me on the show. And just to say that the Institute for Justice has provided me so much research and information that's been very influential on this book. So it's a real treat to be here. So the book is about, as you call it, occupational licensing. I call it professional licensing because it's a little bit different, actually, from the definition that Institute for Justice uses for occupational licensing. I'm interested in those kind of government permission slips to work that require a big investment in human capital to get. So, we're talking about education that you would measure in months, if not years, and testing. So the ones that would be very familiar here would be medicine, law, but also alarm system installers, funeral directors, and hair professionals. This actually excludes some of the occupations that may be in a lot of Institute for Justice's reports, ones where you need to have a weekend CPR course or something to be a coach. This would be an example of an occupational license, but maybe not professional license. Anyway, definition.
And some of them we talk about, it's really like a bonding requirement, right? You have to pay a certain fee. And so sometimes that's called registration, not full-blown licensing. You're talking about the more meaty licensing part.
Yeah, and it's a really onerous form of regulation. It excludes a lot of workers, and it raises prices for consumers. And there really hadn't been a comprehensive book-length treatment of occupational or professional licensing in America that looked at the whole regulatory thing in about 40 years. And so I wanted to write that book. And as you mentioned, I'm an antitrust professor, and I knew going into this book project that we let the professions regulate themselves, that the regulation is done through licensing boards that are mostly made up of members of the profession. So I thought, well, I've seen cartels work. I bet I know what happens at these licensing board meetings, and I'm going to start showing up for my book research and just see what's really going on there. And this book is really a product of what I saw. So the book is very much about licensing boards, not just the laws that restrict work, but also the boards that regulate them. The working title for the book was Bored to Death, which got nixed, but I still sort of love it. And when I showed up at these licensing board meetings, about half of what I saw is more or less what I expected, if it was even maybe went a little further than I thought, as far as raising barriers to entry and keeping workers out and raising prices to consumers through lots and lots of regulation that maybe doesn't protect the public. But then there was this other set of things that I was not expecting at all, that I don't think was on the radar of people who were critical of licensing, like Institute for Justice, which is the disciplinary side of things and how badly boards do the public protection that they're supposed to be doing when it comes to bad providers.
Yeah, that's the aspect of this book and overall your treatment of boards that I think even those of you listening who think, I know all about occupational licensing, I've read work by Morris Kleiner, who is an economist that you mentioned, who's written all kinds of studies on occupational licensing, and if you read work that IJ has produced, what is really different and new and great about your book is how these boards actually function. Like you'd think some public choice scholar in the past would have dug into like how these boards actually work, because it's the kind of thing that libertarians talk about all the time, which is, well, when you look at like how, the Department of Education, even though it's set up with grand purposes, actually works, it actually has all these terrible things that happen. But no one had done that for occupational licensing boards, which really surprised me. But the way that you did it in going to the board meetings, and these people were happy to talk to you, it seems, over the years, is really impressive. And there were a lot of moments in reading your book where, my jaw dropped and like, wow, they actually did that, which you would think I would have been not immune to at this point, working at IJ for 15 years. But it happened over and over again.
Yeah, the regulators were unself-conscious about the ways that what they were doing were actually hurting the public. And I, one thing so I went in here with a sort of cartel model, right? A mustache twirling villains are going to be at this. That's not what I found. The people on the boards were very high integrity. They cared about public protection to the extent that they understood what they did, was going to, the ways in which it was going to affect it. And they were willing to talk to me because, I was somebody who wanted to learn more about what they were doing. And so when I say they were unself-conscious, I guess part of what I mean is they just didn't know or understand the effect that their regulation had, both on, the too much red tape problem, because it's easy to think like, well, we're protecting people. We're making it harder to enter the profession. The people in here are going to be really good at their job. And that's going to be safer for consumers. It takes a kind of systemic perspective on the whole thing to see that the higher you raise the barriers, the scarcer the provision of services, the more people go without, the more people have to pay for it. And then the other side, I think they were also kind of clueless about what happened when they failed to discipline the really bad providers. I think that they kind of had this idea like, well, they'll never work again. How are they going to work again with, on probation or with a reprimand in their file? And the answer is they will go on to work again, just not in the areas of practice that the board members were most familiar with. And in fact, they would go on to work again in areas where maybe they would encounter some of the more vulnerable patients and clients. So the board members were, they were doing their best, in most cases, but my jaw also dropped, having the perspective of like, this should not be about protecting the profession. This should be about protecting the public. My jaw dropped at a lot of the stuff that I saw, too. And that was especially true when it came to the discipline.
So look, I want to get into the discipline because that's some of the most shocking stuff in a little bit. Even if you don't think we should have occupational licensing, at least maybe it should work as it's intended to work, which is to punish people who do bad things. But first, on the boards themselves, you discuss how the people on boards, as you would expect, are kind of some of the leading lights of the profession, the most outspoken, the most networked, right, in whatever state they're in. And so they often wear the hat of the board, but they wear the hat of, say, the professional association that, just like a private bar association, for example, for lawyers, that then does things like lobby the legislature about the law. And they don't see a conflict between those two roles, it seems. Could you talk a bit about that and how pernicious that sometimes can be?
Yeah, so it's funny you brought up hats. I heard a lot about hats. And mostly it was, when I sit on the board, I change hats. I go from being, a member of the board of the Association of Physical Therapists to being a member of the Board of Physical Therapy. And my role is different. And I can compartmentalize those two interests. And when I'm sitting on the board wearing my hat of regulator, I'm not thinking about the profession at all. And I just did not see them succeed in compartmentalizing in this way. I did not see them actually able to set aside their professional interests in thinking about the public. And sometimes nakedly so. The alcohol and drug abuse counselors example that I say in the book, the staff wanted to roll back the requirements very slightly, and it wouldn't have reduced the amount of education, the relevant education that the counselors would have had to have, but it would have made it easier to enter the profession. And the board members said things like, when you open the door, you let the bugs fly in. I worry about pay for our providers. We need to have a more professional profession. It was very much about what this would do for the profession. And this is a profession, by the way, that has 400 people in it only in the state of Tennessee. We have 70,000 people who suffer from opioid use disorder. So this is a profession that really could be much larger, and it has a huge demand. And that I don't call that public protection. That's not public protection. So that can be pretty pernicious.
One license that I know some states have that I've always thought is kind of funny is the alarm installer's license. And you described this alarm installer licensing meeting, I think, where a handyman had installed a Ring camera at someone's front door, and apparently you can't do that without a license. And the reaction of the board toward this poor little, handyman who's doing this tiny little job just seemed to me out of bounds to what the actual health and safety ramifications were for their job, but they didn't seem to, get that was a problem.
No. And in fact, they kind of threw the book at this guy. I think this was maybe before Ring. He had installed some sort of camera system that he got at Sam's Club for his neighbor. And then he put on his business card, it was a handyman business card, and he said he could do this kind of installation. And I think it was especially putting it on his card that really bothered the board. Because it was like, oh, this is going to be competition. He's going to find more clients like this. And in fact, the staff of the board was trying to get them to back off a bit and say, look, we talked to him. He's not going to do it again. He didn't know that you needed a license for this. He bought it at Sam's Club. And they were like, oh no, maximum fine, And the board sort of said, the staff said, well, he only did it once. And then the board said, that we know of. And it was just sort of like this really extreme reaction. And I think that's a perfect example of not understanding how the chilling effect that this kind of regulation can have. I think people are really scared of these boards. That handyman had to pay a $1,000 fine, not to mention just the sort of terror of being hauled in front of a licensing board for installing something from a big box store. So, yeah, and actually, I will note that I think that they've gotten rid of that board since I concluded my research. So that's progress, I guess.
One board down, many more to go.
That's right.
Yeah. The contrast between that I think your book is really valuable for, and how boards treat people on the inside, people who already have a license, which I want to get to in a moment, is really powerful. But what I don't quite understand, and maybe I don't know if this is just a lack of lawyers educating the public, or maybe I just have American constitutionalism all wrong, but it doesn't seem like people, as you describe them, people on these boards get that, say, an interest like protecting public health and safety is far more important than keeping people out of the profession, because it's going to be more, quote, professional if we don't have people who look like, basically they're the riffraff within our profession, and they don't see one as like legitimate and one the other. They see both as legitimate. Do you think that's actually true, or do you think they actually, maybe if they thought about it, are a little embarrassed by this anti-competitive impetus that they have, or is it just kind of lost to them? I mean, why it's lost to them would be a whole different story, but is it just not something that crosses their minds and maybe their staff attorneys' minds?
So I think it is. I think it has crossed their mind. I think that's why I heard about the hats. I think they knew they had to change hats because they understood on some level there was going to be a conflict of interest between the interests of the profession and the interests of the public. But one thing they're able to do is to play up all the ways in which they don't conflict. So, high licensure barriers are likely to lead to more competent providers. That's probably true on some level, it's, to some degree. And I heard an awful lot of, we want to throw the book at the really bad providers because they make us look bad. So, they would say that, they wouldn't actually do it. But there are these ways in which the interests of the profession and the public line up. And I think the cognitive dissonance that they were engaging in was sort of really thinking mostly about those things, thinking that that's what they were doing. They were operating in that space where those things line up. And also I'll say, you said something about the staff. I actually think the staff, the full-time employees, the bureaucrats, if you will, working for the state, but operating as lawyers for the board or executive directors of the board, they were not clueless at all. They actually, I think, fully understood the anti-competitive nature. They are the ones who brought up the case that shall not be named, which is what the boards call.
Which we'll name later.
Yeah, we'll name later. But they're the ones who brought up the possibility of antitrust liability, of anti-competitive possibilities. It was the staff that kind of knew what was going on. And so, and here's where I'll maybe depart ways with Institute for Justice a little bit. I am in favor of more bureaucratic regulation for the professions that we need licensing for, because they were the ones who seemed to understand what was going on. So I don't really want to burn it down, at least not for some professions, not to unfairly characterize the Institute for Justice perspective.
We do have better burning.
I liked the bureaucrats' perspective on a lot of these problems.
So that's an interesting maybe segue we can go into now, that you discuss how in the United States, the model of having a board that licenses and regulates a profession within a state that is primarily composed of practitioners in that profession, which of course is the big antitrust problem, that is super common, right, across the country. But it's not really common in other countries. Now, your book isn't a comparative international perspective, in a deep way, but you do talk a little bit about this. Could you discuss that? Like, I know funnily enough, we think, America, the land of the free. A lot of other modern democracies are not as occupationally licensed as the United States, like the UK, for example. They have their own problems, but they don't have as much occupational licensing. But when they do, it seems like they do it the old-fashioned way with, bureaucrats who, although they're bureaucrats, they're not tied into the profession in the same way that these boards are.
Yeah. Okay. So this is really interesting, the way you framed this question, because I think a lot of legislators think that these licensing boards are kind of small government. They think this is actually a light touch thing because the fiscal report on the creation of a board is zero. It's not going to cost the state anything. It's, essentially the private sphere regulating, which is what maybe you'd want if you believe in small government. And when it comes to discipline and investigations, it's a very light touch, And I remember talking to some Republican and even maybe libertarian-minded lawmakers who made this argument, and I was kind of like, you get what you pay for, and this is big government. Yeah, it looks like small government because these guys are not bureaucrats and not drawing a salary from the state, but look at how much they're costing, not only the people in your state, but for like having to pay for services, but leading to all kinds of failures that are very expensive for the state, like the opioid crisis and the cost of healthcare. Licensure actually has a role to play, I think, in both of those things. So yeah, this idea that the way that America does it is actually small government is an argument that I heard made, and I think it's part of why it proliferated, and I think it's totally wrong. As for other countries, the one I'm familiar with is England, as you said, the UK, and specifically the way they regulate doctors. And of course, they license doctors. But they do it through a regulatory body that's not 100% dominated by physicians. There's a lot of other people involved in that. And then they have this disciplinary system that's a lot more independent and I think expert and reliable. It's a little hard to compare the two in terms of their results, just because medicine is so different between the two countries. But I think that I did an empirical study comparing the outcomes between Tennessee and this regulator in the UK, and we found that the results in the UK were a lot more reasonable than in Tennessee.
In terms of discipline of, bad actors?
In terms of discipline, yeah. I mean, we didn't look at the other side of things. I think that would be interesting to look at too, as far as the difficulty of entering the profession and the kind of barriers to entry that they create in England. I wonder about that. Although there you're really going to encounter apples and oranges because of the NHS and, socialized medicine there.
Yeah. They do have a few private doctors, but
yeah.
Mostly they're government employees, of course. Well, so we keep hinting at how these boards discipline their people on the inside. So you've gotten enough education, you pass the test, you're on the inside of the profession. At that point, things seem pretty good. Now you talk a lot about medicine. And particularly because you've done a lot of research in Tennessee. In Tennessee, a lot of states have gone through this, but Tennessee especially went through the opioid crisis and its impact on medicine. So maybe you can talk a bit about what you found with how Tennessee doctors regulated themselves in that way, but also more generally how it impacts other professions too, that dynamic.
Yeah, so I started with medicine for a reason, and it was because I felt like the libertarian case against licensing that, Institute for Justice has made so persuasively wasn't going to get any traction against medicine because the sort of health and safety risks there were so high that, you wouldn't really roll your eyes at, we need to be worried about life and death, the way that you would roll your eyes at an argument about, hair professionals, that we need to be worried about life and death.
There's a lot of licenses to worry about before that one. Yeah,
exactly. And so I thought, if this self-regulation is going on, I bet it's just as bad. I bet it's just as bad, and we sort of think doctors have it all figured out, but maybe they don't. That's why I started with medicine. And I also thought, this is a really important, everybody could agree that this is a really important thing to get right. And so I wanted to see, are we getting it right? It also, medicine is a small fraction, actual physician licensure, is a small fraction of the healthcare workforce that's licensed. But it sets the tone. It kind of, they're the big guys in the room, and so what they do really trickles down to the largest healthcare profession, which is nursing, and then all the other healthcare professions too. So although a lot of my examples come from doctors, I think that what I learned there is broadly applicable to a lot of the prescribing professions and a lot of the healthcare professions. And what I learned is that as much as they were sort of concerned about patient safety, maybe overly concerned about patient safety when it came to talking about entry requirements and controlling their own competition. They became focused on something totally different when it came to discipline. So if a doctor came in accused of using his license to deal in drugs or having sex with a patient, the scarcity of medicine became foremost in their mind. The scarcity that they had basically created. Yeah. And it was like, oh, well, this doctor has had so many, $1.5 million worth of training. We can't just abandon it. He's potentially this font of consumer benefit. We just need to rehabilitate him. We need to find a way to get him off drugs. We need to find a way to give him a chaperone so he won't touch patients. That's the way we're going to preserve access to care. And I think that I saw some similar things happen at the physician's assistant board with overprescribing, same thing at the nursing board. So it isn't just medicine that's doing this. And the thing that I think is really interesting about this argument is it actually, I think, strengthens what I'll, as a shorthand, call the Institute for Justice position. Because all of the ridiculous things that Institute for Justice has done such a good job of highlighting as ridiculous arguments for why you would need licensure, they're even more ridiculous if you see what boards are doing when life and death is on the line. It kind of puts truth to the lie.
Of course, I'm going to agree with what you just said, but about IJ. But what really struck me in your discussion of these boards is just how many second and third and fourth chances they give to these doctors that are completely out of line, and that it is really only when the criminal process comes in, which of course is not run by doctors, that the board will actually do something. Could you maybe give a couple examples of that?
Yeah. So kind of the revolving door. I mean, one thing I often heard when I talked to board members about a case that I thought was too light, they would say, well, he'll be back. Oh, they'll get another chance to get it right. I'm thinking this is not good for patients. So they're just sending him out and he'll come right back. And they did. I saw examples of, like you said, second, third, fifth chances in front of licensing boards. And you said that the criminal system is the thing that'll stop it. I mean, what I would say is not even then. I saw a lot of people get second and third chances after criminal justice enforcement, criminal justice involvement. But that was a shortcut to findings of fact. Okay, so one thing that we need to know about boards is that they're really underfunded and they're under-resourced and trials are expensive. Oh, and because the boards only meet for 2 days every 2 months, that's the way the medical board meets, but the other boards are similar. If you're going to have a 5-day trial, that's going to take you 6 months.
That was when you told a story about one of those long trials, it was unbelievable that it's actually set up that way. That they have 2 days trial, then they break for a month, then they do a little more trial.
Yeah, and they actually only have 1 day of trial because the first day of the meeting is a bunch of other business. So they do trials 1 day at a time every 2 months. So the thing about the criminal system is that now if you have a plea or you have a trial, you have a set of findings of fact. And you can lose your license. The legislature has set it up so that if you have a criminal conviction of a certain kind, that itself can be a reason to lose your license. And so it becomes sort of administratively easy for the boards to take licenses once there's a conviction. That's part of the answer. But keep in mind, the criminal system can take forever. And so in the meantime, that doctor may be practicing and prescribing unless the criminal judge has figured that out, in which case the criminal judge has to set the terms of their release to be, limiting prescribing. So now you have a judge deciding what's safe for this doctor to do. And it's just goofy. The weirdest thing then, though, is even somebody who has a conviction, often I found the board going a lot lighter than I thought that they would. And I think the idea there is well, he's really been through the ringer. And it's usually he, but not exclusively. He's really been through the ringer. We'll let him keep his license because, otherwise he'll be in even worse shape, and he's already been punished enough.
What it reminded me of, more familiar with, is how little prosecutors are disciplined by lawyer licensing boards, by bars, even when they've done absolutely egregious things. They can't be sued usually because of prosecutorial immunity. And yet the one thing that could maybe stop them from doing all these bad things and coming up with fake evidence or whatever is to lose their license. And that hardly ever happens. And so I don't know if it's actually, no, it's terrible. I was going to say it's kind of heartening in an ironic way, but it's terrible to learn that that's true in other professions as well. Well, let's move on to your background when you started all this, which is antitrust and this case that shall not be named, which we can now name. I can't remember the exact title, but it's the North Carolina dental antitrust case from 2014, I think. I
think it was 2000. Well, the Supreme Court decided it in 2015. And I believe we are almost at the 10-year anniversary,
yes.
to the day. Yeah.
Yeah. So that's the North Carolina board case about teeth whiteners. And so not a lot of people have paid attention to it since then. But I will say we at IJ were interested in it when it happened, because we have been interested in teeth whitening and licensing, because we've done a few cases in that area. My colleague Paul Sherman did a few cases in that area. And I will say the day that the argument happened here in Minnesota, in our little office in Minnesota, we listened to the argument with Morris Kleiner himself and a couple of his colleagues. That was fun.
Oh, that's so cool.
Because Morris, was interested in what's going to happen. So that case comes out and basically says, yes, licensing boards could be subject to antitrust law, the federal antitrust laws, depending on a few factors. And there's been some litigation in that area, some trying to crack down on abusive licensing boards, but there hasn't been that much. So maybe if you could describe kind of, in a nutshell, the background. I know it's complicated as to how these boards might be causing antitrust violations, and then what has happened since then, and maybe why it hasn't gone as far as some reformers hoped it would.
Yeah, so this case involved the North Carolina Dental Board sending cease and desist letters to teeth whiteners in malls, saying, you guys are practicing dentistry without a license, and if you continue to do this, we're going to open disciplinary cases against you.
This is something you can do at home, like super cheaply. These people just help you, get your teeth whitened. That's really all it is.
This is not, we won't get too deep into the statute, but it was a real stretch to say that the statute in North Carolina really described what was happening at these mall kiosks. So let's imagine this was just a private cartel. Okay, so let's imagine that a bunch of dentists got together and said, we don't like that this kind of cheap teeth whitening is happening. We want to funnel our patients into the most expensive, full in a dentist office version of teeth whitening. It's an important source of income for us, which it actually is. And so let's all agree not to deal with or provide any support to or ever do teeth whitening without a full exam and not in the office. That would be an antitrust violation. It would be a sort of horizontal cartel organized around wanting to suppress competition. The difference here is that the dentists who made this plan and executed it sat on a licensing board. And the Supreme Court has said that state regulation is immune from antitrust liability. So you can't sue your state legislature for creating a law that suppresses competition. It's sort of obvious why you have to have that immunity if you think about it for 2 seconds. But the problem is that so much of what states do is not done by the legislature, not done by the governor, the sovereign parts of government, if you will, but it's kind of done by these middle things. Maybe they're boards, commissions, and sometimes they look an awful lot like a cartel. So there's a test to distinguish between government regulation, that's properly government regulation, and regulation that's basically the state saying, hey, you can be a cartel and we'll just go with whatever you want to do. The latter, that stuff, that's supposed to be subject to antitrust liability. And the case really turned on whether or not this dental board was more like a state agency or more like a cartel. And the case said, look, if you want to use, addressing the state. So if you want to use a board to regulate in your name, then you need to, and you want to use a majority of members of the profession or members from industry on this board, then you need to actively supervise it. You need to have much more involvement in their regulation. So that's what the case said. And then it was like, because there's not a lot of supervision of boards, people thought, oh, there's going to be a ton of antitrust liability for licensing boards. And as you said, there was some, but not a lot of actual cases. However, I do think that the effect of the case that shall not be named, but it's the North Carolina Board of Dental Examiners case, has affected the behavior of boards in a good way. It's made them a little bit more self-conscious about their self-dealing.
Okay, and so there may be some cease and desist letters that they don't send out today that maybe they would have sent out 15 years ago, 10 years ago, because at least their general counsel are saying, that could get you in trouble.
Yeah, I mean, I literally saw this. I sat in on board meetings where the board wanted to do something, and then the lawyer for the board said, nope, North Carolina dental, nope, can't do that. Nope, antitrust. Right. So how much effect is that having? Some, not as much maybe as we would have hoped for a case like that. But I mean, the other thing is, I saw so much bad regulation watching the board's work. Very little of it would I have described as an antitrust violation, like an actual suit that is going to succeed, like the teeth whitening case. So I think that that case is important, but it has a limited effect on reforming what's happening at the boards.
Sure. And that's not an area that we do at IJ for many reasons, including we're not antitrust lawyers. But if people are interested, there are a few firms around the country that specialize in that work. One is Bona Law, which is headed by Jared Bona, who's an old clerk of IJ, and another colleague of his, Aaron Gott, is a lawyer who's done work for us in the past. And they do a great job there. So if you have an antitrust problem with a board, reach out to Jared and Aaron, and maybe they can help you. But as you say, a lot of licensing is, especially when it's in this model, the board model, it's not exactly anti-competitive. It's just not exactly put through the cost-benefit analysis for how it's going to help the state, right? And is that part of the problem, that the board is conflicted, or is that really just a problem with democracy and how the legislature sets it up? And there's really only so much blame we can cast at the board members.
So I think it's both. I think you can blame the board members only in the sense that they're not able to fully change that hat, and they go about seeking what's good for the profession. And then what will often happen is that the boards themselves will influence what happens at the legislature. And then whatever the legislature does, as I said, is totally immune from antitrust antitrust liability. So for example, going back to alcohol and drug abuse counselors, you used to have 1,500 hours of practical experience after you finished the education to become a counselor. That became 3,000. That became 6,000. Now, all that is done, which, by the way, 6,000 is about 3 years of full-time work. That would be a medical residency. That is all done by the legislature. So that's completely immune from antitrust laws. There's no argument that you could...
Although it could be on behalf of lobbying by the board members, right?
Exactly. So but boards they drive this legislation. In fact, there was a bill to prevent boards from using licensing fees to pay for lobbying in front of the legislatures that they're supposed to be interpreting, and it failed. So somehow, I guess the professional interest defeated this bill that would have prohibited boards from using their own fees to lobby the legislature. So that, when we look at the legislature going 1,500 to 3,000, 6,000, we have to understand that the board is behind that.
Sure. Well, so all of this, and this is something I warned you I might ask about, all of this mechanics of the board and their interests and everything, hits me in a special way because I am one of the very few, probably the only libertarian public interest lawyer in the country who used to represent labor unions in my old job, my old days. And
you had like some sort of conversion experience.
Well,
I guess.
no, I needed a job, and it was, you know what, it was really fun work, and I got in court a lot, and I worked with great people, and the clients were very fun and interesting, as you might imagine, Chicago labor unions. But they were not my people coming in and coming out ideologically. But so many discussions you put in the book between the board members remind me of how labor unions talk. And now labor unions, they're not regulating the economy. I mean, they are in a grand sense, but of course they are taking advantage of the legal structure, whether it's a public union or a private union, and going about it for their members, as you would expect. And so, for example, one time we were, this is not, attorney-client privilege, so I'm not revealing anything. There were some members talking, and they worked at a plant, and there was some work that they could do, but that was being done by an outside contractor coming in and doing work at the plant. And their argument was, that's our work. Like, we've always done that in the past. It's our work. Now, it wasn't really in a collective bargaining agreement that like they got to do that work. It was just kind of the common law, you might say, of the facility that they would do that. But they really thought that there was like some rule being broken, that they don't get to do that work. And it seems like it's exactly the same thing going on with these boards, that, hey, that's our work. That camera on that guy's front stoop, that's actually our work, even if there's, maybe not really a law that says it's there. So do you see a lot of parallels, like I'm sure you do in some way, between labor unions and boards? Is it underexplored in that way? Or, maybe do you see some differences? So, of course, the labor union isn't going to be as pernicious as the board because, they're not making law, so to speak.
So, yeah, I mean, I think there's this graph that everybody likes to talk about when they talk about licensing. It's in one of Morris's books, Morris Kleiner, the economist you mentioned earlier, where union membership is, as a percentage of the workforce, goes from super high in 1950 and kind of, just all the way down to the present. And then licensing as a percentage of the workforce goes in the exact opposite direction.
Right.
It starts low in the 50s and it goes up to high in the present day. This has prompted a lot of people to be like, oh, one is substituting for the other, or, there's some kind of causal relationship going on here. I don't think that has to be the story of why those lines are intersecting. But what they do illustrate is that, one way of organizing labor has really taken over for the other, in the sense that like it's just a lot more important of an institution now than the licensing is than unions. And the similarities are important to note. So as you said, the sort of self-interest in the organization and the professional like betterment is going on for sure in both. Unionization and licensing tend to raise wages. But there's also some really important differences. The biggest one you've already hit into that, which is that a union is organized. Nobody expects it to be anything other than self-interested. The point of a union is to vindicate the interests of its members.
Right.
And then the point of unionizing is that you then get a seat at the table across from management where you hash it out and there's a more even kind of distribution of power in deciding on the terms of those contracts. That process is protected through, the outcome of that process is not just decided by the union. Obviously, management has a major role there, and there's a lot of law about what can and can't happen in those agreements. That's not the way licensing works. It's like we handed the whole thing over to the union,
Right.
And then just said, you're the government now. And also unionization is like, the whole point of unionization is to better worker conditions. That's not what licensing is supposed to be about. It's this back door, sort of under the guise of public protection. If we wanted to use licensing to protect workers, it would look totally different. So I do think there's interesting parallels, but at the end of the day, some progressives have made this argument that like, oh, we need to preserve licensing because it's the new union. And I just think that's really wrong.
So how do we make this better? You talked a little bit about having more bureaucrats, which it is less shocking than it sounds. I'm sure there's other ideas you have. We've done a lot of litigation at IJ, but as everyone knows, that can't be the only solution, even if the courts were different than they are today. So where do we go from here?
Yeah, I think that the entity with the most power to fix this are the state legislatures. And what they need to do is they need to get rid of a bunch of licenses. So the way that we did in Tennessee for alarm system installers, we need to do that for, half dozen or a dozen other professions. And that's just the start. I think we also need to overhaul the way that we do licensing boards for the remaining professions that need licensure. Basically, you're going to want to reduce the influence of members of the profession. You could do that by vesting the decision-making authority in government. So there's somebody at the Department of Commerce and Insurance who is in charge of burial services. This is people who operate graveyards and also do cremation. That is not a program run by members from that industry. It's just run by the government. That would be one way to do it. So kind of get rid of licensing boards. Another way to do it would be to change the composition of these licensing boards and make them less than 50% members of the profession. I think the first solution is a little bit more dramatic and maybe a little bit harder to pursue politically. But I think the second is really possible. I don't think there's any reason why we need to have 9 out of 12 doctors on the boards. And it'd be cool if the rest of the people on that board were not, had some sort of expertise and interest in this area too.
Now, in terms of your idea about having just the government do licensing, I can hear my free market friends whispering in our ears right now that you're still going to have some kind of regulatory capture, as they put it, in that instance. It's not going to be the same because the members of the profession won't, basically have a cartel in licensing, but they're going to be pressured from the same association. The legislature is going to get the same pressures. And so in the end, is it really going to be all that different? In fact, it could be even worse because then they're going to have the full hand of, say, the centralized authority of the state instead of this board. What would be your response to that critique?
I don't think it'll be worse because I don't think they'll have any more governmental authority than the boards already have. Like what we have right now is the worst of both worlds, where you have all of the special interests of a private organization and you have all of the state power that we would associate with government vested in this licensing board. So I don't think it'll be worse in the way that you describe. Will there still be a capture problem? There could be. And that's why we should only do this for professions that really need it and, where there's a real public interest in having licensing. And, we can't, at least I can't single-handedly solve capture. That's a problem that, is gonna come up. What I can say is that I compared the burial services program to, which is the way I described it, to funeral directors. Funeral directors is governed by a board of funeral directors, of course. And the regulation there is just much more onerous. So to the extent that the Burial Services, Professional Association has tried to capture the assistant commissioner who runs the program, it hasn't been as successful as it has over the years in funeral services. So I think it's important to see that, yes, capture is a problem, but these boards, they're just born captured. They're just inherently captured. You don't even have to capture them because it just is industry.
When there have been successes, so you did mention this, the licensing board in Tennessee for alarm installers that was disbanded. There's other examples. What does anything strike you as what made that possible? Like what came together where you actually do get deregulation or re-regulation in a good way of these industries?
Well, the answer to that question is like a little bit depressing because I think that the answer is there is not a large organized professional organization on the other side of that argument. So I'm not sure that the alarm system installers of Tennessee came together in a way that was effective to fight against that. And the reason why I find that depressing, also, by the way, we did away with licensing for beauty pageant operators, and no beauty pageant operators showed up to that meeting of the legislature. So that was a slam dunk.
There's a beauty pageant operator license?
Yes, there was.
Is it just, and any other states have that?
I don't know.
That's a new one on me.
But no more. We don't have it anymore. And it's because no one showed up. I don't even know if anyone had this license, you know?
Yeah.
What that suggests is that if we pursue licensing reform in this way, and we don't do it in a more kind of a bigger picture and take big, bold steps, we're just going to trim away at the margins of these smaller professions where the public risk is really small. And I guess I'm all for that. Like, why not? But I don't know that that's really going to cut at the heart of the problem. We have to take on the organized interests of the professions. We have to take on the AMA or the state level version of that if we really want to fix this.
Anything else you'd like to tell our listeners? A reason that they should read your book?
Oh, I think it's actually kind of, maybe I'm tooting my own horn, but I think it's more fun to read than you might expect. I don't know if you're allowed to swear on this show, but I think one of the best compliments I got was from somebody who's actually in the book. He said, "This was way more interesting than some of the boring shit I sometimes have to read." So what I will say is that my book is way more interesting than the boring shit you sometimes have to read.
All right. Well, we're not going to put that in the tagline for the episode, but because you gave sufficient warning to people who may have children in the car, I think that's just fine. So the book is The Licensing Racket: How We Decide Who Is Allowed to Work and Why It Goes Wrong. By the time you're listening to this, it is available for sale right now. So please go and order your copy today. And Rebecca Allensworth, thanks for coming on.
Thank you.
And thank you all for listening. Please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.